What's going on? How you doing? I'm good, man. I'm good. Just taking care of business. Just another day for me. Let me know if y'all have any questions. But y'all, I got some stuff to talk about, but just want to see. I know everybody's doing their own thing, but let me know if what y'all are curious about and looking over, or but yeah, let me know. Let me know what questions y'all have. Got a couple things I can talk about. Guess I'll start out with, if you're not aware, just start out. Constitution is not the law of the land. Treaty of Paris is supreme over that. This is why so many people get discretion with regards to, different constitutional arguments, things like that. So, touching on that, I asked it, are there any similar cases like Hamilton versus Eaton, 1796, that admit the Treaty of Paris, done in 1783, is the supreme law of the land? And it said yes. There are cases and legal references that recognize treaties, including the Treaty of Paris, 1783, as the supreme law of the land, consistent with Article 6, Clause 2 of the U.S. Constitution, the Supremacy Clause. While Hamilton versus Eaton, 1796, explicitly applied the Treaty of Paris, other cases have similarly reinforced the principle that treaties made under U.S. authority hold supreme legal status. Here are some examples. Ware versus Hilton, 1796. This case addressed conflicts between the Treaty of Paris and state laws. The Supreme Court ruled that the treaty took precedence over a Virginia law that allowed confiscation of debts allowed to British creditors, affirming that treaties override state legislation. Foster versus Nielsen, 1829. The court reiterated that a treaty is, quote, to be regarded in the courts of justice as equivalent to an act of the legislature, end quote, provided it is self-executing. Though focused on land disputes from a treaty with Spain, it emphasizes treaties as binding supreme law. Yeah, absolutely. They had to acknowledge it somehow. You're absolutely right, John. United States versus Schooner, Peggy, 1801. This case upheld that treaties must be respected and applied by courts, even when they affect pending litigation. It underscored the binding nature of treaties like the Treaty of Paris. Missouri versus Holland, 1920. While not directly about the Treaty of Paris, this case upheld federal treaties as supreme, even over state sovereignty. It confirmed the constitutional principle that treaties can supersede state laws. Fairfax Devizes versus Hunter's Lacey, 1813. This case involved land rights and British subjects under the Treaty of Paris, 1783. The court reinforced the treaty's role as a supreme legal authority, resolving disputes tied to its provisions. Broader significance of the Treaty of Paris done in 1783. The Treaty of Paris was central to the legal framework post-Revolutionary War, addressing estate recovery, recognition of debts, and rights of British subjects in America. Notice its verbiage. Its implementation through cases like Hamilton versus Eaton and Ware versus Hilton established it as a primary source for interpreting rights under the new nation's legal system. Rule 220, in the context of a legal procedure, typically pertains to evidentiary and procedural standards for admitting and recognizing foreign or historical laws, treaties, and documents as authoritative in U.S. courts. Depending on the jurisdiction and the specific rulebook being referenced, Rule 220, or its equivalent, could be tied to judicial notice of laws or treaties, presumptions about their authenticity of their application. Judicial notice, application, recognition of estate recovery, Treaty of Paris, Article 5. Article 5 of the Treaty of Paris, 1783, explicitly calls for the restitution of estates, rights, and properties confiscated during the Revolutionary War. You could argue that modern laws or judicial doctrines invoking estate recovery, exempli gratis, the SSKV Act, are still subordinate to the treaty's recovery provisions, aligning with the Rule 220. Authenticity of foreign documents and their historical context. That is preserved in public records. So, presumption of continuity. No subsequent treaty or statute has invalidated the estate recovery and debt protection provision under Article 5 of the Treaty of Paris, and courts must apply these terms. So the Treaty of Paris' estate-related clauses dovetail with equitable doctrines, requiring trustees, including states or courts, to account for and restore withheld property or credit. So, just some things to think about. So there's plenty to know there. Just some things to ponder on. It depends on whether or not you're, the copper-colored indigenous Shemites or not. If not, then not really. If at any point you migrated here, at any point in history, then no. But, there's a lot of things, especially claiming that you're not a citizen. A citizen is a piece of property, intellectual in nature. Native just means you were born here. Indigenous means you were originally here. Or original peoples. The original peoples were the so-called copper-colored, the so-called black Americans that are today disenfranchised a lot of times. Other than that, everybody else is a migrant. But I mean, like I said, there's gonna be a lot of people deported. A lot of people deported January. So if you're still claiming to be intellectual property such as a U.S. citizen, I would be changing that right now. Yeah, but that partnership is only as good as the corporation is here. Corporation was established by military occupation and eminent domain. So as such, when the emergency disappears, so does their power. Things will definitely change as far as that. But yeah, most people are unaware of how, things actually stemmed from, like I said, the original land, or the original law of the land, was originally British law, monarchies and kingdoms, United Kingdom, the monarchies. What's going on, Roots? So, Constitution was not supreme. Go read Hamilton versus Eaton, Ware versus Hilton, 1796, both of those cases. Virginia and North Carolina, if I'm not mistaken, for those two cases. So, like I said, those particular treaties expressly declare that the provisions made in treaties such as the Treaty of Paris, 1783, are the supreme law of the land. They supersede state sovereignty. What's going on, David? So, the Constitution is essentially just a key way to keep people busy, to be honest with you. It's a corporate charter. It doesn't secure the rights of men and women, only persons. The British estates were always in America. They started here in America under the Britannian Empire, Roman Britain. Roman Britain was here in America prior to the Reconstruction Acts. The Reconstruction Acts are when they brought it overseas to the Isles, the British Isles, where it is currently located today. England, where it's presently located, is considered the British Isles, or Isles Britannica. But that's not the original land. It's a territory. The original land is here, all of the Americas, under the empire known as Britannia, or the United Kingdom. The Treaty of Paris just essentially subjugated a different faction that was making war with essentially the United Kingdom, but didn't actually, other interests overthrew it with the 14th Amendment, the Civil War, General Order 100, the Lieber Codes, District of Columbia Act 1871, 1874, and 1878. So ever since mid-1850s or 60s, we've been under martial law. And that's why people don't get remedy with the Constitution when there's things higher than that supersede. If you don't know international law, you really don't know how to operate. International law is based on feudal law of season, conveyancing, tenure of lands and tenements, how an estate is held, how an estate is conveyed, what are the terms for how the estate is held, things like that. That's what allows people to basically come in under the right law form. These treaties, when you understand treaty law, it's just private international law, or essentially private contract law that's done on an international scale. No, it took effect. People don't understand what happened in the 1800s. The 1800s was a time where they had far more technologies than we have today. People could invent things. Why is it that there's so many different not so dangerous chemicals and other things that allow for various types of creation of energy producing devices that are not allowed in this day and age? Because it affects private interests. That's why. So, like I said, things happened in the 1850s to 1860s as a form of takeover, corporate takeover by military power. The military power is what is occupying this land right now, and is not the original jurisdiction or ownership of this land. The original we the people, like I said, copper-colored Indians. 1776 was the start of the Cherokee Indian War. What's going on, Pegs? It's definitely, truth is stranger than fiction. And when people really realize what's going on, a lot of people have a hard time reconciling it sometimes. But case law and other law forms and precedent and other things will tell you more than what any historian would like to say. And civil procedure is maritime jurisdiction. Read Clerk's Praxis. Under Clerk's Praxis, the civil jurisdiction arose from the realm and domain of the admiral, or the title of admiral, which is itself a French naval office. Which is why in gambling and wagering they say parlay. So, yeah. Military occupation is something that's done under the laws of war. And it's important to understand the laws of war and how it relates to prisoners of war. For those that have eyes, there's a POW MIA flag in many prominent places, especially different government offices. So, not necessarily, but it depends on the type of entity. But the civil jurisdiction deals with the realm of the dead as well. So, dead things often go to the sea, the abyss. So, yeah, 771. Yeah, you know. Yep. So, but I mean, yeah, like I said, it depends on how the entity is formed and what you're doing. There are different ways to use certain things. It just depends on what the nature of the entity is. Red ink denotes a debt owed. It's symbolic of blood ties, which are a lien or levy on the soul. I tend to stay away from it other than when it's absolutely necessary for certain things. This is why you get the term red ledger. A ledger owed, or in criminal acts or dangerous people or things like that. So yeah, I mean, I've heard of it though, but I prefer either, when writing accounts, I prefer black. When writing names of living people, I prefer blue or purple. And when acting as a role as an agent, officer, or administrator, I prefer blue. Authorized rep, a lot of times blue. Purple deals with probate. This is why a lot of probate clerks use purple ink. So, red indicates the blood. It's dealing with a blood tie. People used to sign their name in blood when they made a soul contract. This is why red writing is treated as a debt. It's not something to be done lightly. This is why every word in the New Testament is written in red. With certain fictions. So, but yeah, I generally stick to those colors. Blue is the water, dealing with currency matters or business. The administrator. Purple is probate. Red is a serious debt owed. And then black is dead, dealing with administration of dead things, accounts, etc. Legal fictions a lot of times. Thank you, Roots. But if you can walk around with a blue, a black, and a purple pen, about 2 of each of those, you should be straight. You shouldn't need too many other colors. Green has implications for creation of currency. Green deals with life, abundance. But unless you're the minter of a specific coin of currency, it doesn't really hold as much value. And technically you can, but it becomes a debt on your entity and all that. So it's a whole other conversation. But yellow is symbolic of gold, but gold isn't even being used right now. So it just depends. But yeah, generally, like dealing with stamps and other things, generally it's black ink. if you're dealing with, other things, that's, like I said, usually blue or purple, one of the two. Yeah, blue represents the sea, the currency, the law of water, which is why the administrator is in that realm. The agent, authorized representative, personal representative, things like that. Those are all in the realm of commerce or business or international trade, international matters. So things across the waters, which is why they're in blue. So there are times when you have to use it because you don't want to use black, and they won't let you use anything other than black or blue. They'll cease to recognize it. So it's better to have blue than it is that. But know the position and parties that you are and how you operate. That's why you have to know your role. Like a Christian Walters kept harping on. What type of relationship are you creating with the way you are presenting yourself on documents and signatures and the rule of forms? Are you the administrator? Are you the grantor? Are you acting on behalf of the principal debtor? Are you the personal representative? Are you the authorized representative? What are you doing? Who are you? Are you an entity, or do you represent one? Not necessarily. They're not necessarily that, but when you write in black ink, you're treated as a dead entity, especially when you sign in black. Because a sign is a mark, and if that thing represents you, then that means you're dead. That's why they have trademarks, service marks. That's why people sign in blue ink. Definitely is wild. And like I said, there's so many things that you can do, but realistically speaking, it doesn't go very far if it's not recognized or its meaning is misunderstood. So that's why people need to learn the language of symbolism. The language of symbolism is an unspoken language that conveys meaning, influence, and power without speaking a single word, and often more than words can say. The language of symbolism is expressed through imagery, art, sculpture, seals, signs, etc. And it's something that most people are illiterate to and have no understanding of. A sign or a symbol is a representation of the real thing, and what it denotes some true kind of presentation of information, to which can much can be inferred from. I don't know, I've heard that, but if you're gonna say something, it would be like under protest or without prejudice, or you have to go check your local, your law merchant, UCC provisions, or etc. Whatever's controlling, your jurisdiction. If it's anywhere in the States, UCC. If it's another, you have to look to your law merchant or your whatever specific set of codes or statutes that controls what merchants do, how security interests are perfected, and all that. And in those same codes, it should tell you how rights are reserved, reservations of rights, things like that. All communication is based on symbolism. Each letter has its own meaning and its own numerical meaning. and everything ports to some number by meaning or weight in the way it's expressed. This is why people go to numerology. Now, where it goes off the rails is when you try to start divining stuff and predicting the future based on that. That's just going too far. Because the Most High has power to make even the diviners mad. But understanding the significance and the meaning behind certain things and behind certain numbers, yes, it is a language in and of itself. And it tells a lot. Quite a bit. So, even numbers have meaning. Numbers aren't just symbolic of a certain amount or group or a quantity of something, someone or something. They're also denominative of certain meanings conveyed by those particular numbers. 1 being wholeness, singularity, individuality. 2, usually something combined into 1, a lot of times, or multiplied and turned into 2 ones together. 3 is fruits. 4 is also fruits. 5 is God-given. This is why so many fallen and demons love to use pentagrams, because it corrupts, takes away from the true meaning. 6, those 6 days of the week. Labor. This is why there's so many negative connotations with 6. 7 is rest. 7 days in a week. 8, destruction of the void, the wilderness. 9, a lost thing, something lost. 10 is perfection or destruction. So, and there's various other meanings, but that's what they, especially in Strong's biblical concordance, that's what they confer to. So, those different numbers have their own meanings and significance, and understanding those helps to, it helps to understand a lot. I mean, not really. I mean, the actual number is different. Especially when you go back to Hebrew, they're different numbers. Now, there are patterns that are involved that make certain things like digital roots and other things that go into each other. So I can see what you're saying, yes, but the quantities are different. But the digital root is dealing with 3. 3 times 2 is 6. 3 times 3 is 9. 369 hertz is, a key frequency. H316 H369 is not in Strong's biblical concordance. So but it goes into the larger understanding of patterns, frequencies, fractals, energy as expressed in waves. People need to understand that energy, everything in creation is some form of sound or energy. Energy is expressed in one of 2 ways: as a wave or a particle. As a particle, all it is energy collapsed and contained. As a wave, energy is expressed via some form of sound. So everyone in existence, matter is a lower, more dense form of energy. And everything, everyone has a prime resonant frequency, like Terrence Howard says. Your prime resonant frequency is your core frequency. This is also partially in tune with, it's really has a lot to do with your soul purpose. I believe it has a part in it. It deals with the meanings of certain numbers, when certain things are done, how the things were created, conferred, the meaning of those numbers upon the numbers themselves by the Most High. It was the order and the operation and the way things were created that gave the numbers their meaning. So understanding the things from their origin gives you understanding as far as how things are now. I don't believe in religion. Religion means to meaning again, or and then liege or legare or legion means to join. So it means to join again. And when you pay attention, the New Testament talks about legion. It is a flock of demons. So religion is literally the same demons they were worried about. What is Christianity? It's a religion. So the very thing they warn about is the very thing they are. All these religions, every religion is a trap. Spirituality is the truth. Although you have to be careful what you do in that realm. But the Torah and the Tanakh are the real laws. It's just law and chaos. Law and disorder. Polar opposites. Nah. Buddhism, all they do is call a stone wise. Buddha in Hebrew means wise. So all they're doing is worshiping the form and similitude of a man that cannot speak, cannot think, cannot hear, and cannot save. Buddhism is a lie. So is Taoism, because they worship the energy and not the creator. As such, it's asinine and ass backwards. I would be remiss if I didn't speak on that. The earth is supposed to be the mirror of heaven. There are multiple heavens. It says it in the book of Enoch. The earth is supposed to be the mirror of what goes on above. As above, so below. As below, so above. Yeah, even Taoism. Tao is the creative energy from which things were created. And then the Most High further divided and created between the yin and the yang. Yin chi and yang chi, which is give and take, masculine and feminine. Push and pull, light and, night and day. Sun and moon. The duality. Two parts of the same whole. But over those things is the Most High. And the energies themselves are not to be worshipped, only the creator and the source of the energy. Yeah, well, like I said, I'm not going to lie to you. I ripped out all the New Testaments and just about every Bible I have, I think. Yeah. So, I read the Torah, the Tanakh, and the Apocrypha. And those are the laws that I adhere to my best to. Because if Congress went so far in 1982 to declare the Bible as the Word of God, for them to acknowledge something, them being so heinous and wicked, the sheer fact that that's something they acknowledge holds quite a bit of weight. They want to absolve themselves from karmic responsibilities, well, they have to say it somewhere. And the karmic scales is just the scales of judgment, of equity. You receive what you put into the universe and all of creation. But, I mean, the Torah and the Tanakh, that's really what it is, John. Because, yeah, you know, what is a son of God? A son of God is an Elohim or an angel. So tell me what that means. Isaiah 14, Revelation, they both say the same thing. But if you read that, the Old Testament, Leviticus, Exodus, Deuteronomy, Proverbs, Psalms, Wisdom of Solomon, the Book of Enoch, those are the things that really tell you what goes on. Because the thing about it is that one can only judge from their own perspective. So until you reach a point of understanding, a lot of times it remains faulty. This is why we have to lean not to our own understanding, but rely on the Most High. And yeah, like I said, Leviticus 6. Leviticus 6 deals with, you know, suretyship, trust, and all those different things. And you understand what goes on. Another thing is understanding how one's own word is their own bond. Yeah, but the only way to do that is go find out what they are in the manuscripts. The manuscripts are the original books. They were compiled into a canon. A canon is a Roman statute, meaning that was all they deemed to be allowed in the public, for fear of the original peoples of the Most High waking up, reclaiming their identities. At a certain point, all will know. And a lot of people inherited lies. And yeah, the courts know. This is why the bar knows certain things. This is why the attorneys have titles of nobility, esquire, etc. Because those supersede everything in the Constitution. The treaties supersede all of that. Because that's the underlying jurisdiction. The Constitution and all that. It's just a corporate overlay. And that's all that a lot of people know. But when you really go down to it, it's all acts of Parliament, Westminster, statutes and ordinances of kings and monarchs times prior. So and most people don't understand, Treaty of Paris was done in the place known as Paris, Texas today. Paris, Texas, at one point was ruled by the French, and at that time, that was one of the flags that flew over Texas. Same with, other places. Babylon, New York City. It was the city of Eboracum, or York, England. So it's the same as the old ancient city, just re-established and reconquered. Now administered under another name. Yeah. The French held a lot of power. There's a lot of things going on. Treaty of Paris, title of Admiral. Why is the Navy so intrinsically tied to the French? Maybe it has something to do with the French-Indian War. I wonder. That was another civil war that people don't understand. But yeah, I hope everybody's changing their name, getting their private trusts going. There's a lot of things people need to be doing right now. If you want to learn how to day trade and deal with, futures trading and other things like that, go check out my associate's channel, Abundant Lifestyle Trading. So, the Ames River, Connecticut, Norwich. Yeah. Connecticut is one of the oldest cities. Canterbury, Connecticut is the original Canterbury, England. Colchester, Connecticut is the original Colchester, England. Colchester, England was, Colchester, Connecticut was founded in New London County in 1666 as a direct response to the Susquehanna Act. Yeah. Changing them names. Capital letter names belong to nobody. And there's a difference between nobody and nobody. So, same as there's a difference between someone and no one. Capital letter names belong to those of the dead, and they are satanic in nature, as they are symbols instead of letters, and it forms another alphabet. Yeah, abundant lifestyle trading. Yes. He started his channel recently, so I think he'll be posting more. But yep. He is, yeah, go check him out. He's very knowledgeable. Like I said, get your trust done, get your name changes done. Go make sure those assumed names are done properly. I wonder for what state. Futures options. I know he likes NASDAQ and I think S&P and other things. So So there's a very clear reason why I'm telling people to do certain things. I can't elaborate on it too much in the public, but go get your name changed. Don't be that capital letter name. Don't be the implied surety for that principal debtor, that decedent. They got you surety for another a placenta and an afterbirth that you spent 9 months in, and now it's going to haunt you for 90 years. People ask if voodoo and witchcraft is real. Why, very yes it is. And the most worst place it's ever been, and the most prominent place it's ever been, is in the courts. So, learn what suretyship is. Learn understanding, fulfilling performance under bonds and obligations and duties. Discharging duties, performing under a contract or an obligation. Performing under a bond and making good that word. Keeping your word. Word is bond. It's a saying on the street because it's true. The only thing you have is your word. You break that, you have nothing. No, you're not the all capital letter name, even if you are so-called paying a bill. All you can do is endorsement for presentment to another party. You can't actually pay any bills right now. Especially not under this military occupation. And no, you're not that capital. I mean, at least from what I'm aware. I mean, if you're claiming to be a fiction, I'm not gonna stop you. But it's not a good thing to claim. That's why you say agent or authorized representative or something on behalf of that name. Because that name is a corporation. It's a bankrupt corporation. Even in 1933, all they created was a bankrupt estate. Right, until you get a court order saying you're not. When you got a court order, now the judge can't say, "Oh, I didn't know." People wonder why they have so many problems with encroaching egos in their psyche and their personality. It's because they're wearing a mask until they realize they're playing under a game of persons. They call it a person because you have your purse on you. Yeah, it is under the doctrine of joinder. So you have to separate the corporate identity from the living man or woman. You have to understand how the word identity was broken up. You have ID and you have entity. Does that make sense now? What are the two formed together? The identity. Yeah. It's all fun and games in La La Land and the realm of the dead, the land of make believe. Until you step up and stop playing games. That's why they have you on all these different courts. These courts for these games. Basketball, football, tennis. All of them are just games you're playing around as a person till you finally step up and you invoke equity. There's no adequate remedy at law. Nah. Trusts in a state. Understanding how things are moved. How things are settled. You have rights, you have titles, and you have interests. The grantor conveys a right against the trustee to the beneficiary or the cestui use. Cestui trust. And the title is then conveyed to the trustee, the title of ownership. Now the cestui use retains a right of action or a chose in action, or a choose in action, however you pronounce it. It's multiple. I've seen multiple spellings. And as a result can bring a suit or make a claim as the rightful owner of the property. And equity regards the beneficiary as the true owner. So in the public, everybody sees the trust. In the private, the beneficiary is completely concealed. And the trustee has the duty of accountability only to the beneficiary a lot of times. But yeah. Understanding the rules and positions that you use and create in international trade and business and your affairs and your dealings with other companies. Well, we're presumed not to be the beneficiary. There's certain terms of use for this trust that they have construed because they've construed themselves to be grantor and beneficiary. Because you were presumed dead, lost at sea, lost in commerce, treated as a commercial interest. So the only one who has the right to reconstrue the trust is the settler. Where are you? Your footprints went on that document. Your mark as the grantor. You are the settler who settled upon that piece of paper before you ever reached the land. This is why they treat us like property. So don't let someone else tell you who you are. You want to be able to determine that for yourself. That's what the autonomy is. Etymologies will lie to you. But auto means self, and nome means name. So autonomy is the state of being able to name oneself. That's what true autonomy is. That's how you govern your own affairs. When you can decide what name you take on because you manage the responsibilities of any name you create and go by and make good your bonds, you can have multiple names. That's what common law names are. Everybody thinks that just because you have a bank account in that name, and just because you have this and this and this in that name, it doesn't make it you. It's a construct, figment of the imagination. Especially since there's no such thing as a middle name. It's a fiction of law. Everything's under corporate. Everybody does business under corporations and stuff like that. LLCs, corporations, limited partnership, limited liability entities, trusts, so, all these different forms of business. Every business is a corporation at this time. Yeah, but like I said, once you find out, the clock starts ticking. Equity aids the vigilant and not the indolent, meaning don't sleep on your rights. Otherwise, the doctrine of latches can be applied. There's no statute of limitations on fraud, but as soon as you start, finding stuff out, you have to act. It's different if you got to study to obtain the understanding, then file suit. But you have to be doing something. Yeah, so you have to do something. Like I said, there's a bunch of equitable doctrines. The doctrine of latches. The doctrine of, trying to bar people from equity. Other things. So, the sooner you act on something, the better a lot of times. Just make sure it's the right move. But, understand the differences between the different types of entities in your jurisdiction. Find what best suits you. Generally, trusts that own businesses, foreign trusts that own businesses that don't fall under domestic laws. They're foreign by nature because they are not domiciled in the state where they operate or the country where they operate. So, understand, people, you have to understand the difference between domestic and foreign, domestic affairs and foreign relations. When you understand that, things get a lot simpler. This is why you need to understand conventions and treaties. But yeah, go check out his channel. He's put in a lot of time. So if you're curious about market structure and, you know, charting and things like that, especially with dealing with the futures and other things like that, you know, yeah, go check out his stuff. Yep. But yeah, understand the different doctrines of equity. There's many different doctrines that provide relief when there's no adequate remedy at law. That is something that can be alleged. So when there's no adequate remedy at law, a lot of times, even if there is an adequate remedy at law, there are equitable maxims that play into obtaining both remedy and relief. Remedy at law, relief in equity. They have to be handled accordingly. A lot of relief is private. Awesome, Roots. I'm glad that helped. So, but yeah, subrogation is a key doctrine, especially understanding things with bonds. Bonds, a lot of bonds are maritime in nature, the way that the civil system has been set up. What's going on, Carissa? So, yeah, let me know what you want to cover. Just going over some different things. Subrogation is something that can be used to good success, especially dealing with maritime bonding and certain claims in admiralty and civil situations. Yeah, like I said, he knows a lot of this type of stuff, but he knows the markets. So, like I said, you know, subscribe to him. You know, go ahead and leave some comments up there for him if you got questions. You know, go ahead and check his stuff out, because, you know, he's good at what he does. Yeah, and understanding, a lot of people need to understand where the lines are. If you understand what the roles and duties and responsibilities of each role or position that you take on in whatever law form you do, then you understand where they stop and where they start. And that is one of the beginning key phases of understanding the different boundary lines. If you understand the boundary lines, you know where they cross. If you know where they cross, you know where to look for interplays of jurisdictions. So, let me see this. What else? What's something that I haven't covered too much? Oh, I guess I'll talk about latches. I've mentioned that a couple different times. Latches is a legal doctrine that prevents a plaintiff from bringing a claim if they unreasonably delayed asserting their rights to the detriment of the other party. It is also known as estoppel by latches. Latches is different from a statute of limitations, which prevents a claim from being brought from a certain amount of time has passed. Latches is an equitable defense, and the party asserting it must prove that it applies. The delay must be unreasonable and cause prejudice to the other party, such as by making it difficult to find witnesses or evidence. For example, if the defendant can show that most or all of the witnesses are now deceased due to the delay, the court may dismiss the claim. However, a plaintiff can excuse a delay if they can provide a reasonable explanation, such as lack of information. The word latches comes from the old French word lâche, meaning slack. So be diligent. Don't be slack-handed. This is what they mean by due diligence. Unreasonable delay. What is this an estoppel? Estoppel is a legal principle that prevents someone from going back on their word or making assertions that contradict what they previously said or agreed to. The term estoppel comes from Anglo-French word estoppere, meaning to stop or stopping. Equitable estoppel, key doctrine. Especially dealing with contracts and things like that, estoppel is very key. Especially when certain representations have been made prior, estoppel is something that can be used to good success. Yeah, but that just means they're asleep, pegs. I've dealt with my fair share of people sleeping, but it's no point. It's like arguing with a brick wall. If you keep butting your head against the brick wall, the only thing that's going to bleed is your head. But yeah, understanding those doctrines is a big part of it. Another book that I highly recommend, especially to keep your own mental composure, is The 7 Spiritual Laws of Success. By Deepak Chopra. That was the word in the name. There we go. But yeah, that book is something I'd highly recommend, especially understanding, coming to terms with certain things that have happened, especially the traumatic experiences of the birth certificate and the things that it imposes upon the soul. And for those that are, deal in the markets and other things, Psalms 107. Psalms 107, 1611 KJV. Read the footnotes. Like I said, any other questions, let me know. So, when you're dealing in the courts, make sure that you're dealing with incorporation by reference. You have identifiers that you come up with to identify your documents on all the pages, and make sure you have page numbers on them, so that way you can clearly delineate that those documents are being controlled by those identifiers, and that you have a specific title to refer to in the event of any confusion. It's something that you should be aware of as far as courts. I've seen countless situations where they say, oh, we lost the document, oh, we did this and that, only to demand that the pro per party is a pro se litigant is then forced to produce another document or redo the same documents. So that's something to be aware of. Identifiers, incorporation by reference, making sure you have certificates of service for everything that you mail out, making sure that there's a clear chain of title, and incorporation by reference of everything that has been served, everything that's been filed, everything that's been shown or exhibited, all of those different manners. Those are definitely some things to bear in mind. Make sure you're bringing in your information in the court the right way. Make sure that you have all of your, you proofread the document. So, but yeah. There are higher burdens of proof upon pro se litigants than there are attorneys. So, bear that in mind. is it called? So, let me see. This is a document that is very important in understanding trusts and estates. It's not a long document, it's about 30 something pages, but it tells you quite a bit. So, let me see. Here's a key part of this. But the suggestion is that the cestee, which is referring to the beneficiary, nevertheless, with respect to the ownership of the equitable claim, so the beneficiary is the owner of the equitable claim, meaning he has the right or ownership of the action. He owns that suit. And he possesses a right in rem jurisdiction, meaning over, the property, as in that proceeding. In rem proceedings are generally considered maritime or civil. With respect to persons other than the trustee, this was recognized by Professor Langdale, the most stalwart defender of the theory that the right of the cestui trust is a right in personam. He said, quote, here again, when it is said that equity cannot create rights in rem, reference is had to the res, which is the subject of the equitable obligation. Regarding the equitable obligation itself as the res, there can be no doubt that an equitable obligation, like a legal obligation, always creates a right in rem, i.e., an absolute right, as between the obligee and all the rest of the world except the obligor. That this suggestion is sound does not admit of doubt, but that it tends in any way to establish the proposition that the right of the cestee is a right in rem in the trust res itself does not seem so clear. It is familiar learning that legal ownership of a chose in action gives rise to rights in rem. It is the duty of the obligor to do or give the thing which he is obligated to do or give by the chose in action, which makes it a right in personam. But it is the duty of the rest of the world to refrain from interfering with the right of the obligee against the obligor. Choses in action, because of their nature, cannot be trespassed upon or converted, but insofar as they are capable of being throw its protection about them and give them the character of rights in rem, as to all persons other than the obligor. Thus, in Anglo-American law, the tendency is to liken the ownership of a chose in action more and more to the ownership of a chattel, as to persons other than the obligor. By process of the application of combined legal and equitable principles, or by statute, choses in action have become freely transferable, so that ownership of a chose in action has assumed many of the characteristics of a right in rem. That ownership of a chose in action was a true right in rem was recognized to a limited instrument embodying or representing a chose in action, the measure of damage being reasonable value of the chose in action and not the value of the parchment or paper. So this is what I mean when I refer to choses in action. But I highly recommend people check this out as well. It's a key aspect of that. In light of this suggestion, let us now ascertain the theory upon which the Sesticate Trust is able to assert any right against subsequent makers of trust property. This is called the rights of the Sesticate Trust. It's a law review. And it's Columbia Law Review. The act of interference. Okay, so it says, upon an examination of the authorities, the following propositions will be found to be of practically the universal application where equity imposes liability upon third persons with respect to property held in trust. That whatever third persons are held responsible because of their interference with the trust res, the act of interference must amount to an acquisition by a transfer of the legal interest held in trust from the trustee to the third person. That equity never imposes liability with respect to trust property upon third persons unless the defendant has notice of the trust or knows the facts which would place a reasonable man on inquiry with respect to the trust, and which consequently the law regards equivalent to notice. Equity often imposes liability upon third persons with respect to trust property, although they have not, in fact, physically transferred or physically interfered with or acquired possession of the trust res. If these propositions are true, it will at once be observed that the real reason for the liability of the third persons is the unconscientious interference with the right in personam, which the cestee has against the trustee, and which, as we have already seen, is a right in rem, as against all the world other than the trustee. He is liable, not because he has interfered with the trust res, of which the cestee is equitable owner, for there are many such interferences which are wrongful and unlawful, which nevertheless give rise to no rights in the cestee, but only when and because such interference is a direct interference with the chosen action which the cestee holds against the trustee. If such should prove to be the nature of the cestee's right, it would follow that the right of strangers to the trust is much more closely analogous to the legal right of the owner of a contract against strangers to the contract, which was recognized and established in Lumley versus Guy. The action there was, of course, at law in tort for the interference with the legal right, but in Lumley versus Wagner, where the plaintiff was entitled to an equitable remedy on his contract, it was held that equity would restrain third persons from carrying out a contract with the plaintiff's contract, or which involved a violation of plaintiff's contract. Contract. Where did it go? Okay. This and many cases which have followed it have established firmly the principle that equity will protect equitable rights in personam from unconscionable interference by strangers, regardless of whether the equitable obligation relates to property or not. In the case of a trust, the equitable right of the cestee is interfered with, and the wrong done is in fact an equitable tort to the right of the cestee against the trustee, which entitles the cestee to a It is just here that the elasticity of the equitable remedy gives rise to superficial resemblance to the right in rem, enforced by legal remedies. For this equitable tort, equity sometimes holds the third person responsible in damages, but on the other hand, since in many cases it is the acquisition or retention of the trust property by the wrongdoer which prevents the enforcement of the cestee's equitable right in personam against the trustee, equity will not allow the wrongdoer to retain the fruits of his wrong. That is a maxim of equity. This is so, not because his act is a wrong to the right of the cestee in personam against the trustee, which, if enforced against him, would have resulted in plaintiffs acquiring the res, as, however, the remedy is not necessarily the recovery of the trust property and may be invoked when there is no physical interference with the trust res or acquisition of the trust property. The right asserted cannot be said to be a right in the trust res itself. Let us now ascertain what kinds of acts by third persons are regarded by courts of equity as invasions of the right of the cestee trust. We are at once confronted with striking difference between the rights of the cestee and the rights of the legal owner. Rem of the bailor is literally a right in rem, because the right is invaded exclusively by the incident of acts on the thing itself, which in legal contemplation are injuries to the thing and hence to the rights in the thing, while the owner possesses rights which may be invaded by mere physical interference with the property, however innocent so far as their moral character is concerned, amounting to trespass or conversion or disseason. Such acts affecting the trust res are not regarded by courts of equity as invasions of the rights of the cestee, while the bailor may maintain trespass, trover, or replevin, and the disseisee may maintain ejectment or one of the various forms of the real action against the disseiser. Equity affords no equivalent remedy to the cestee trust. If, therefore, the cestee trust has a right in rem to the trust res itself, we shall have to admit that, unlike any other right in rem, it cannot be invaded by a tortious destruction of the res, which is the subject of the right. There are, however, various kinds of interference with the trust property, which equity does regard as invasions of the rights of the cestee purchaser with notice. The innocent heir or donee of the trust property is deemed to have invaded the right of the cestee trust, who is given rights against the person, thus acquiring the legal right of the trustee. What is the essential distinction between these two classes of acts? In the latter class, it is noted that there is a breach of duty on the part of the trustee, or at least a failure to carry out the duty which equity imposes on him by reason of the fact that he is a trustee, whereas in the former class, there is no breach of duty on the part of the trustee. It is the duty of the trustee to hold the legal right in the trust res, with respect to which he is vested, for the benefit of the cesticate trust, or else to vest that interest in the cesticate trust, and so long as he retains that interest, he must avoid negligent acts or omissions with respect to it. Thus, where there is a sale or gift of the trust res in breach of the trust, there is a violation of the personal duty which the trustee owes to the cesticate trust. So this is something that, like I said, I would definitely read into. So that's some stuff to look at as far as choices of an action, choice of action, or choice of venue, if you will. But it allows for better understanding of what can be done as a beneficiary, especially with regards to the legal estate. The legal estate, there are certain things that you can do as a result in certain times. So I would definitely read into that more. Anyone have any questions, comments? Like I said, let me know. Let me know what y'all want to talk about. I know everybody's got their own thing going on, so it might end early depending on what goes on. Anyone have any questions? Like I said, if you got any questions, let me know. Put it in the chat. You are supposed to do that in the county that you have the principal address in. So, what were the reasons for their denial or their trouble? What were they trying to maintain? They're not supposed to be able to deny you for an actual notice. It may depend on what you did and said in the notice, but they're generally not supposed to tell you what you can and can't publish. Yeah. You may be able to say that you have a business in Minnesota that requires you to give notice there. But like I said, see what the issue is first. Alright, yeah. Just call them though, because like I said, just let them know, if necessary, you have a business in Minnesota that requires you to give notice according to statute. And regardless of state regulations and where you live, you still have to give notice. So the other thing too is there might be more than one paper. I don't know. Sometimes there's only one. So just see what they do. Absolutely. Any other questions? Do 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 do. Yeah, absolutely. Yeah, so like I said, let me know any other questions. Y'all been getting those system names in, name changes, other things like that. Got any questions? Let me know. Let me know. Whatever questions y'all got, let me know. I'll do my best to answer them. Do my best. That's all I can do. Any other questions? Let me know. Anyone seen any good movies lately? Well, I'll probably go another 15 minutes, 20 minutes, something like that. See how everything goes. Yeah. Yo, well, like I said, I know it's everybody got their own stuff going on. Shoot. I know that there's a few things. Like I said, make sure y'all correcting your name and through the court. Make sure you're setting up the private trust, conveying your estate to your trust, getting it out of the public domain, reclaiming your securities and security interests, perfecting that via whatever modes or means you deem fit. Oh, yeah. Like I said, if they ask, well, if they say, well, this isn't really a name change per se, you say, yes, those two names are different. One has been spelled in proper case, one has been capitalized on. And that capital letter name belongs to nobody. The only people I see with capital letter names are people in cemeteries. And it's against my spiritual beliefs to spell my name in all capital letters, seeing as it's satanic in the GPO style manual under chapter 3.35 under religious terms. Words specifically denoting Satan are all capitalized. Absolutely. Absolutely, pigs. Absolutely. Once you start mentioning the spiritual beliefs, loses a lot of hold on that name. Yeah. Yep. So, like I said, get them things done, get them accounts corrected. It's like 30 days to file your BOI filings for FinCEN. Make sure you get that done. So, yeah, make sure y'all do all that. So, yep. Yeah, get your trust set up that way. Well, I'm working on that, but once you get the trust set up, then then you can get those things filled out. So yeah. What else is there? There's a few other things, but make sure you get rid of different things like marriage licenses, etc. Make sure you start claiming accounts, putting people on notice, start copywriting your own name, your own estate. There's multiple methods of doing that. Make sure you got a fee schedule. Make sure you get all that stuff in order, so that way you understand. Read the Revenue Act of 1862. I mean, I have some availability next week. As far as this week, I'm pretty much booked up. I still have a few things to do, and then I have to get those trusts in order. Um, but I do have some time this upcoming week. So just let me know. I think potentially like Wednesday through Friday I might have some time. So just let me know. So, yeah, any other questions? Probably give it another 10 minutes and I'll wrap things up. Any other pertinent questions? Let me know. Let me know. Well, I hope everybody's taking care of themselves and not overindulging. Um, you know, especially while you're doing all this stuff, meditation helps keep all this stuff straight, keep your mind in order. Being outside, depending on where you are. But yeah. But yeah, stay focused. Due diligence is key. There's a proverb also. See thou a man diligent in his business, he shall stand before kings, he shall not stand before mean men. So like I said, any last questions? Let me know. Let me know what questions y'all have. Yeah. Hope everyone is putting in that work, getting their stuff corrected. I'll have a class tomorrow at 7 p.m. Eastern. So on the private equity weekly workshop. So we'll be going over some very pertinent stuff, very, very important. So that's some stuff that you'll want to watch out for. And yeah. So other than that, any last questions for the night? Thank you, Roots. Thank you, Roots. Well, other than that, y'all stay safe. You know, take care of yourselves. And yeah, I'll catch y'all on the next one. This is B with To Be Fruitful Training Group. All praises to the Most High. I'll see y'all on the next one. Good night, y'all.